Maryland Realtors Global Business Committee. My name is Lori Benner. I'm the Director of Housing Programs, and I'll be the moderator. For those of you interested in furthering your knowledge of international real estate, Maryland Realtors is offering the Certified International Property Specialist Designation Series in August, and you can find out more information on our website. For today's presentation, if you'd like to submit a question, you may do so on the right-hand side of your screen using the Question tab, and it will be answered at the end. Now I'd like to introduce our presenter, Richard Chisholm. Mr. Chisholm is an attorney and CPA with a robust international practice, and we're grateful that he'll share his expertise with us today.
Good morning, everyone, and thank you for calling in for this seminar. I'd like to thank MAR and also Lori Benner for helping us to arrange the seminar and giving me the opportunity to speak to you this morning. Living in or having investments in the United States leads to complicated tax and legal issues which, if left unaddressed, can cause a host of unintended and expensive consequences for your clients. Our discussion today is going to focus on the issues faced by non-U.S. persons who purchase real estate in the United States. So for ease of reference, let's just call those folks global clients. I'm also going to discuss some tax issues that confront global clients when they decide to become residents in the United States. So many global clients who purchase real estate in the U.S. are unaware of the scope and extent of U.S. tax laws. Ideally, the global client becomes educated about these laws before they commit to a transaction, but as we know, that doesn't always occur. Some of the global clients that you'll work with decide to come to the United States and actually live here on a permanent or semi-permanent basis. For those clients, it's important to address any outstanding compliance issues promptly in order to avoid incurring additional taxes, penalties, and interest. It's also worth noting that the IRS is focused on enforcing U.S. tax laws as they apply to a U.S. person's foreign assets and income. So the way that would work is you would have a global client who would buy real estate in the United States, they would become a U.S. person, and now they would have obligations to report all of the assets that they now own outside of the United States to the IRS. So with that introduction, let's move into slide one. So who's a global client? For purposes of this discussion, it's anybody who's not a U.S. person. And that means that the person is not a U.S. citizen, a U.S. resident, a U.S. corporation or partnership, a U.S. trust, whether that trust is revocable or irrevocable, or an estate of a U.S. person or a foreign person, actually, that has U.S. source income. What are the consequences of being a U.S. person? Well, once a client becomes a U.S. person, they become subject to the full range of U.S. taxation on their worldwide income and assets. That includes income, gift, and estate tax. Once they become a U.S. person, they're also required to file a host of information reports with either the IRS or the Department of the Treasury that discloses various types of information regarding their foreign assets and investments. We're going to talk in more detail about those information or income tax, estate, and gift tax reporting requirements and the information reporting requirements in a few minutes. But really, I think from your perspective, the question becomes, what can a realtor do to be helpful to a global client? And I think it's helpful to look at this from a couple of different perspectives. I think the first thing you want to think about is whether the global client appears to be a U.S. person. If the buyer is not a U.S. person, then they really are a global client. And we've got some additional planning that the client may want to enter into before closing on the deal. A referral to competent tax counsel at this point could prove very beneficial to the global client. However, if the buyer is a U.S. citizen or a lawful permanent resident but has assets outside of the United States, that person will also most likely be obligated to report the existence of those assets to the IRS and is required to report any income earned by those assets on his or her personal income tax returns. There's usually time between signing the contract and the closing to get the buyer to a competent tax advisor. This can be critically important for the global client purchasing U.S. real estate If they engage in appropriate planning, they can avoid running into serious difficulties in the future. But we need to keep in mind that that planning can take several weeks, if not longer, to complete. So you want to leave time in order to accomplish whatever planning the global client wants to undertake. The planning itself can be expensive, but for global clients, the financial consequences of failing to do any planning can be significantly more costly. The last thing I'd recommend is that when you're drafting sales contracts for global clients, it's helpful to include language allowing the contract to be assigned to an entity that's formed by the global client once the planning occurs. In order to accomplish some of the objectives that we're going to mention in a few minutes, you really need to have that it's helpful if the global client has that real estate owned by some type of a corporation or other type of entity. So I realize that some of you may feel that introducing complexities like U.S. income tax and information reporting obligations to your client is outside the scope of your responsibilities to the client and could slow down or kill the transaction. And those points are well taken. They could be correct depending on the situation. But consider the following. You may be the only person the global client is consulting who has any knowledge about these issues. If you can educate your client about the issues that affect them, you can avoid problems that could interfere with the closing. And if you're on the sell side, you could avoid problems like FIRPTA and estate tax liens that could present problems. So providing a global client with sound advice early enough in the transaction timeline can save them from time and trouble and can cement your relationship with them and lead to further business. So what are some of these key objectives that your global clients have? This slide is intended to give you some talking points to convince the global client to get some advice on U.S. tax laws. Your clients typically are going to want to achieve many of these objectives when they buy U.S. real estate. The problem is if they don't plan properly for acquiring and operating the real estate, they are going to fail some of these and they're going to be unhappy. So that's why proper planning requires a client to be willing to invest in and tolerate the complexities of an appropriate structure that will help them achieve these objectives. So what happens to a global client when they purchase U.S. real estate? And I note that this is a purchase either individually or through some type of an entity. Some of these complications can arise in any situation like that. So the first thing an individual client's going to have to do is they're going to have to register with the IRS to obtain an individual taxpayer identification number. An ITIN is what it's referred to as. An ITIN is used by the recipient on various income tax and information return reports that they file with the Internal Revenue Service. The global client is given a choice as to how income taxes apply to real estate. So for many of them, and we'll talk about this in more detail, they're going to have to decide whether they want to have withholding on the gross rental income or whether they want to expose the rental income to taxation by the feds and by the state in which the property is located. On sale, the global client will have FIRPTA withholding, which is equal to 15% of the gross sale proceeds. And as we know, FIRPTA withholding occurs at the settlement table. So the client's not going to receive those proceeds. They're going to be turned over to the Internal Revenue Service. In addition, the global client must pay U.S. capital gains tax and/or ordinary income tax through depreciation recapture when a property is sold. That computation occurs in the same way it would for a U.S. person. It's no difference. But that FIRPTA withholding that we just talked about is going to be used to offset that tax liability. In addition, if the global client is an individual and he or she gives an interest in the property or in an entity which owns the property to another person, the global client may have U.S. gift tax consequences. If the global client dies while owning the real estate, whether that ownership is individually or through an entity like a corporation, an LLC, or a partnership, the global client will likely have to file a U.S. estate tax return reporting his or her worldwide assets to the IRS, and they might incur a U.S. estate tax liability. Further, a deceased global client may also face probate proceedings in the jurisdiction in which the real property is located if he or she dies while owning the property in his or her individual name. As noted earlier, there are various ownership structures which can be put into place to help the global client avoid or minimize some of these issues, but there's got to be sufficient time to allow them to do so. The most effective of these structures involve the creation of at least one U.S. corporation, one foreign corporation, and perhaps an irrevocable trust, depending upon the buyer's goals and objectives. So you can see where there's going to need to be time for the client to consult with competent counsel, get the decisions made that are necessary to draft the documents, review the documents, and then get them signed. This also goes back to why we need an assignment clause in the contract in order for the property to be purchased by the appropriate entity. And there's no one-size-fits-all approach here. Each client's going to have slightly different factors which are going to go into how we structure some of those entities. So again, just sufficient lead time is really the most critical factor here. So let's briefly look at who is a U.S. person. And remember, we're dividing the universe into those who are U.S. persons. And I'm using the term person. In the legal sense, it could be an entity or an individual. And we'll go through each of those. But we're dividing the world into U.S. persons and then what we are referring to as global clients or non-U.S. persons. So if a client has already, if an individual is either a citizen of the United States, is a lawful permanent resident, i.e. they have a green card, or they satisfy what's referred to as the substantial presence test set forth in the Internal Revenue Code, then they are a U.S. person. If a client is already a U.S. person, when you meet them, then that client is fully attached to the United States for all income tax and information reporting purposes. As mentioned earlier, many clients who have immigrated to the U.S. are not aware of the full extent of those obligations, and realtors can be helpful in referring those clients to competent tax advisors. With that in mind, let's review how a person or entity becomes a U.S. person. So, first test is the individual a citizen? Again, I realize you're not immigration attorneys, so these definitions are here simply to allow you to issue spot for your clients. I would note there's a lot of disinformation, misinformation out there regarding how one obtains or acquires citizenship. So a brief review of these tests I thought would be helpful. Most of us know that anybody born in the United States, regardless of the parent's nationality, is a citizen. However, individuals born outside of the United States can also become citizens in the two instances described on this slide. Finally, someone can immigrate to the United States from another country and go through the citizenship process and be granted citizenship. So those are the primary ways that an individual can become a U.S. citizen. What about lawful permanent residents? Lawful permanent residents are also U.S. persons. So if a client has a green card, they are taxed in the same way as a U.S. citizen is and are subject to the same obligations. So a lawful permanent resident is someone who has received legal authorization to live and work in the U.S. on a permanent basis, and they are actually going to have a physical document that's referred to as a green card. I've given you the U.S. Customs and Immigration Service form number there. If they have one of these in their name, then they're a lawful permanent resident unless they've decided to relinquish it. And they ought to know if they did that. It's very difficult to do without knowing that you've done it. Again, so if the client's got a green card, then they are a U.S. person. So let's talk about this substantial presence test. If a client satisfies the substantial presence test, and the client is taxed in the same way as a green card holder or a U.S. citizen, for our purposes, that means they're a U.S. person. The substantial presence test can be a very painful trap for the unwary. You basically become subject to the substantial presence test if you spend too much time in the United States. And clients who are traveling here because they have family here or they have business interests here sometimes don't realize that the amount of time that they're spending in the U.S. is accumulating, and if they cross the threshold that's defined by the substantial presence test, then they are going to attach to the United States for U.S. tax purposes. This test can easily trap a client who stays here too long, and clients frequently accrue U.S. tax obligations and that they don't realize they've accrued, and that can be a significant problem for them. So slide sets forth the tests. Again, competent tax advisor probably needs to be retained to walk the client through this if it looks like they're getting close to being substantially present in the United States. Some people who come to the United States and satisfy the substantial presence test can benefit from one of these two exceptions here. If they can prove a closer connection to another country, then they can sometimes be, at least to the IRS's satisfaction, they can be accepted from the substantial presence test. Or if they are a citizen of another country that has a tax treaty with the U.S., and they can satisfy the treaty's tiebreaker rules for determining residency between the individual's home country and the U.S., then they can benefit from that exception as well. Again, the determination of a closer connection and the use of the tiebreaker rules to avoid the substantial presence test is something that an experienced tax advisor is going to have to do or help the client go through. It's got significant risks because if you make a determination that is incorrect, the client is non-compliant with U.S. tax and information reporting obligations. Penalties and interest are going to attach, and it can become a significant issue for the client. So again, substantial presence test catches a lot of people. There are these two exceptions, but the exceptions can be difficult to satisfy, and if you do satisfy them and you're wrong, you've still got a significant downside. So this becomes very complicated very quickly. Some other types of U.S. persons, a U.S. corporation or a partnership. And when we say that, we're referring to an entity organized under the laws of a political subdivision of the United States. If the entity is organized outside of the United States, then for all purposes, it's either a foreign partnership or a foreign corporation. That would make them a non-U.S. person or a global client, as we're using that term here. I'm including here, without saying it, limited liability companies. It's important to note that limited liability companies do not have a separate status under the Internal Revenue Code. They are taxed either as sole proprietorships, partnerships, or corporations. A lot of clients, I'm sure you know, come with limited liability companies already formed. Again, that's not a tax status. You have to determine how they're being taxed, and then you can apply the rules for whether or not the entity is a U.S. person. Trusts can be U.S. persons. For a trust to be a U.S. person, they have to satisfy a two-part test. A U.S. court has to be able to exercise primary supervision over the trust's administration, and one or more U.S. persons must have the ability to control all of the trust's substantial administrative decisions. Usually that's a trustee, but sometimes there are multiple trustees, or there are trustees with differing sets of powers. You could have a trustee handling the administration, and you could have a trustee handling distribution of the trust's assets to the beneficiaries, for example. So it's satisfying that control test can sometimes be a little challenging. Like many definitions in the Internal Revenue Code, if you don't satisfy this, the trust is not a U.S. trust. Therefore, all other trusts are foreign trusts. Let's go ahead and move down to estates. Estates are a little unusual. The knee-jerk reaction I think most people would have is if you're a U.S. citizen or permanent resident or you're substantially present in the U.S. and you die, that your estate is automatically a U.S. person. That's not the case. An estate can be characterized as a resident or non-resident in the U.S. without regard to whether the decedent was a U.S. person or not. The IRS applies a series of facts and circumstances tests that are set forth on the slide, only some of which are set forth on the slide, to determine whether an estate is a U.S. person. That doesn't necessarily, it doesn't exempt income that's effectively connected to the U.S. from being taxed in the United States, but the inquiry still needs to be made. This usually arises when the decedent was living outside of the United States, had been living outside of the United States for a long period of time, families outside, centers of, most of their assets are outside the United States, et cetera. We're actually working with a situation like that now. So it is not that uncommon. All right, so if a client purchases a piece of U.S. real estate, a global client, they've got a series of issues that arise, as we've been alluding to. So I want to move into a discussion of some of those issues, and I'm going to start with the withholding obligations. In order to encourage foreign investors to comply with their U.S. income tax obligations, Congress has established a relatively complex withholding regime. It's not that well known, at least in my experience in talking to your colleagues, so I want to spend a few moments and go through this. Stated somewhat simply, the foreign investor is supposed to decide whether he or she wants to be treated as being engaged in a U.S. trade or business. They can decide that they are, but frankly, if it's a one-house or two-house purchase, or if the asset isn't being rented out, it's just being held vacant, the chances of them actually meeting the requirements to be in a U.S. trade or business are slim, probably not going to make the test. So the IRS gives them an election that they can make to be treated as being in a U.S. trade or business. It's when they're not in a U.S. trade or business that the withholding issue arises. If they're in a U.S. trade or business, then as we'll see in a minute, they're going to pay income taxes, they're going to take deductions, they're going to get depreciation on that real property just like a U.S. person would, and they're going to have to file a U.S. income tax return. It's when they're not in a trade or business or don't elect to be in a trade or business that we're going to get this withholding rate. Most clients that I've seen have not elected to be in a U.S. trade or business and are taking the withholding rate. So this raises the question of what happens to the amounts withheld from the gross rental income, if any were withheld. So let's move on to the withholding agent. So the withholding agent is the person who has control over the rental income. It's not uncommon for someone who lives outside of the United States but buys real estate that's going to be rented out in the U.S. To appoint someone in the U.S. to collect the rent and put them in a U.S. bank account. That person is the withholding agent. It can be a realtor, it can be a management company, it can be a close personal friend, it can be a relative. I've seen all of it. The problem is that it becomes the withholding agent's responsibility to do the withholding. And it's a facts and circumstances test. If there's no clear individual who's doing it or if multiple people are doing it, then that test is going to have to be reviewed. The withholding agent has all the responsibility here. They have to get the client to declare whether or not they're in a U.S. trade or business. If the client is not in the trade or business or doesn't make the election, then the withholding is going to apply. And the withholding agent has to take out of the rent every month, or however often it's paid, the appropriate percentage of the gross rent. Now, the basic percentage is 30%, but if there's an income tax treaty between the client's home country and the United States, you may see a lower withholding rate applied. The withholding agent not only has to collect the money, they also have to pay it over to the IRS. And they have to do that on an annual, monthly, or quarter monthly basis, depending upon the amount of the tax that's withheld. If they fail to do that, and they fail to do it timely, the IRS can assert penalties and charge interest to the withholding agent. In addition, the withholding agent's got to file appropriate reports regarding the gross rent received and the amounts withheld as specified on this slide. The global client's left with the obligation to either inform the withholding agent that they are or they elect to be treated as being in a U.S. trade or business, or to inform the withholding agent that they want to have the flat withholding on the gross rental income withheld from them. In addition, if they say they're on a trade or business, if the global client elects to be treated as being in a trade or business, then the global client must make estimated income tax payments just like they were a U.S. person. They've also got to file a Form 1040-NR. That NR stands for non-resident, by the applicable due date of that return to report their rental income and expenses. So that's how this process of withholding or electing to be treated as a trade or business works. Every client, whether they're a global client or a U.S. person that owns real estate, has the obligation to pay tax on their rental income. So each client needs to think this through. If you have clients who haven't been performing these tasks and haven't been complying with these provisions, they really need to be advised to get competent counsel to get them into compliance. Because again, if you're the withholding agent, there are going to be significant penalties and interest. If you are the client's elected to be treated as being in a trade or business and hasn't filed the 1040-NR, then they're going to potentially have income tax liabilities and penalties and interest on the income tax liabilities. So addressing this sooner rather than later is imperative. All right. Sometimes we have folks who have come to the United States, achieve status as a U.S. person in the United States by either becoming a citizen or attaining a green card, and they have decided that they no longer want to be here. They don't want to be connected to the United States any longer. Most of the time they want to avoid all of the information reporting requirements and the income tax issues and the estate and gift tax issues that they've acquired. There's a way to do this. It's called expatriation. I think I want to slide too far. All right. So anybody who doesn't want to be in a U.S. person any longer has to follow a two-step process. In step one, they relinquish the document establishing their status as a U.S. person with the applicable government agency. And in step two, they have to inform the IRS of their change of status by filing a Form 8854 in the year of, or for the year of expatriation. And we see clients want to do this who have come to the U.S. for a particular purpose, and they've accomplished that purpose, and now they know, as I said, no longer want to be attached. These procedures seem relatively straightforward and easily accomplished. The difficulty is step two. Most people who do this by themselves without any advice fail to file that Form 8854. If the client relinquishes their status as a U.S. person and they fail to file the Form 8854, then they do not separate from the U.S. for tax purposes, and they're still obligated to file income tax returns, to file international information reports. If they die in that status, they're still potentially a U.S. person. They could have U.S. gift tax obligations. It just gets complicated. So it's got to be done correctly, and the problem is that folks fail to do it. So let's look at expatriation. Expatriation is done through the U.S. State Department. It requires submitting certain forms to the State Department. You typically have to appear for an exit interview with the U.S. Embassy or consular official in the country in which the global client resides. After that exit interview, the global client is going to receive a Certificate of Loss of Nationality, a CLN, from the State Department. It's very important that they retain that CLN and that they carry that with them every time they come back into the United States. If you're a U.S. person, many of you may know, you're not allowed to travel into the United States or exit the United States on any passport other than your U.S. passport. if the State Department's or CIS's computer system hasn't been upgraded properly and they see the global client trying to enter the U.S. on another country's passport, they may be stopped. They'll need the certificate of loss of nationality to prove their status. So that's citizenship. What about a green card? So green cards are relinquished through the Department of Homeland Security. You have to follow local embassy or consular requirements for filing what is called a Form I-407 with Homeland Security. And in some cases, again, Homeland Security is going to have you appear for an exit interview before a U.S. consular or immigration official. Once that happens, they're going to take your green card, and that'll be the conclusion of the person's status as a permanent resident of the United States. But again, once either of those two administrative steps occur, the Form 8854 has to be filed. It's also possible to voluntarily lose a green card, and there are the tests on slide 24. If a client wants to try and voluntarily relinquish a green card, they really need to consult with an experienced immigration attorney to make sure that they do it appropriately. But they're still going to have to file that Form 8854 once they do that. All right, so what's the IRS want to make sure has happened to anybody who's departing from this country? Well, they want to make sure that they've complied with their U.S. income tax international information report filing requirements. And again, if they fail to do that, then they're not going to separate for U.S. tax purposes. And this is why the Form 8854 becomes important, because that's what tells the IRS that the client is no longer a U.S. person. One part of the Form 8854 that trips up a lot of people is the required certification under penalties of perjury that the filer is a U.S. income tax and information reporting compliant for the preceding 5 years. If the client hasn't complied with either or both of their U.S. income tax or their international information reporting requirements for the preceding 5 years, they need to do that before they expatriate. And that's going to require typically going through one of the offshore voluntary disclosure programs that I will talk about in a little bit, that will allow them to come into compliance. Once that happens, and they can proceed to expatriate or relinquish their green card. Another difficulty on the Form 8854 is determining whether the individual is what's referred to as a covered expatriate and whether they must pay an exit tax that's computed on the Form 8854 when they file it. So who's a covered expatriate? So the categories are there. A lot of people are going to avoid the first two. If the net worth issue is a problem, if the client's got a net worth in excess of $2 million, it's possible to undertake some planning by making gifts to get there, or doing some other things to get that net worth below the $2 million threshold. I would note, however, that the $2 million is measured or valued by using U.S. gift and estate tax principles. This is not something that a lot of tax advisors have experience doing, so you need to find someone who's got the capability of doing that if the client's going to go through this process. The third one's the compliance requirement that we just talked about. If they file the 8854 and they haven't come into compliance with this, then regardless of whether they satisfy either of the two prior tests, they're a covered expatriate and they're subject to the exit tax. And finally, if they fail to file the Form 8854, then they become a covered expatriate and they're subject to the exit tax. So failing to comply can be expensive, and is another reason why folks need to get competent advice. Sometimes people who appear to be covered expatriates can qualify, I should say, for an exception, and slide 27 just kind of sets forth those exceptions. We're running a little bit short on time, so I'm going to leave that to your review later rather than go through it now. So I've been talking a lot about U.S. tax and information reporting obligations, let's switch gears and let's talk about some of those issues. Note that what I'm about to talk about, let me rephrase that. If your client is or plans on becoming a U.S. person, they're taxable in the U.S. on their worldwide income, and they're subject to the requirements that are set forth on this slide in item 2. They've got these annual international information reports that they have to file. The catch here is it's not a tax form. They're not paying a tax for disclosing information to the government. It's the penalties that apply. That's the catch. So there are substantial penalties for non-filing. These returns, or excuse me, these information reports are due either with or at the same time as the income tax return typically. The F-bar is the one that catches most people. That FinCEN Form 114 used to be due on June 30th of every year. The deadline used to be non-extendable. It was a hard deadline. Just within the last 2 years, that time, that filing requirement has changed, and it now it coincides with the U.S. individual income tax return filing requirements. So what are some of these U.S. information reports? And here you've got a list of some of the more commonly encountered ones. I'm not going to bother to review this in detail other than to tell you again or emphasize again that there are substantial penalties for non-filing. And sometimes clients can even be charged criminally for willfully failing to file these returns. We're going to discuss how to cure failures to file both income tax returns and also these information reports a little bit later. I want to turn really quickly to U.S. gift and estate tax filing requirements. As you may know, all U.S. persons are subject to tax on transfers of their worldwide assets that occur either during lifetime or at death. Similar requirements can apply to non-U.S. persons, but they only apply to U.S. situs assets. So now you should be thinking, okay, I've got a client lives outside the United States, but they own real estate in the U.S., and something happens to them, are they going to have a U.S. estate tax concern? The answer is yes, they will. U.S. estate and gift taxes are imposed on the fair market value of the assets on the date of transfer. You see the 2 deadlines. The estate tax return in particular is a little unusual. It's 9 months from the decedent's date of death. It's counted to the day. In other words, it's a month calculation, not a day calculation. So if someone dies on the 21st of February, the estate tax return is going to be due on the 21st of November. There's an automatic 6-month extension that's available, so you can go out to 15 months, but that extension does not include an extension of time to pay. So if there's going to be a U.S. estate tax liability, it needs to be paid at the 9-month deadline. Let's talk about the scope of U.S. taxes in a little more detail. On the left-hand side, U.S. citizens or residents, what we're referring to as U.S. persons. One thing that's unusual about the U.S. estate tax is it's based on a definition of domicile that's included at the bottom. Domicile is defined as the place in which an individual lives and to which the individual intends to return whenever he or she leaves. It's a facts and circumstances test. So what that means is somebody can be a green card holder or satisfy the substantial presence test for income tax purposes and not be domiciled in the U.S. for estate tax purposes. This is a separate inquiry. If they are a U.S. person, then they're subject to tax, estate tax on their worldwide assets, including all of those listed there. If they're not a U.S. person, then they're subject, now I'm on the right side of the slide, they're subject to tax on their U.S. situs assets only. Those include tangible personal property located here and real property located in the United States, shares of U.S. corporations, and certain debt obligations of U.S. persons. The estate tax is applied differently depending upon whether you're a U.S. person or not. If the decedent's a U.S. person, there's currently a $5.49 million federal estate tax exemption. Assets above that amount are taxed at a flat rate of 40%. If the decedent's married to a U.S. person and doesn't consume his or her exemption, that unused exemption can be transferred to the surviving spouse. This is referred to as portability. However, if the decedent is married to a non-citizen, then the remaining estate tax exemption is lost. We can address those issues if we have time to do proper estate planning for the client before he or she passes away. Under U.S. law, you're allowed, if your husband and wife are both U.S. citizens, to transfer assets to a surviving spouse and obtain what is referred to as a marital deduction. Conceptually, that means that if the husband dies and leaves all of his assets to a surviving spouse, regardless of the amount of those assets, no estate tax would be paid. Unfortunately, this doesn't apply. This, what's referred to as the marital deduction, doesn't apply when the surviving spouse is a non-U.S. citizen. In that case, we have to set up a special type of trust called a qualified domestic trust to avoid those assets being taxed immediately at the first spouse's death. It's also worthwhile that some states, and currently including Maryland and Washington, D.C., have an estate tax that's based in large part on the federal law. Rates can be different and exemptions are different. Neither state has portability currently, but the underlying issues involving ownership of assets, valuation of assets, etc., it follows federal law. If the client's not a U.S. citizen or resident, then you can see that those $60,000 thresholds are a heck of a lot less than the $5.49 million exemption given to U.S. persons. So a filing obligation arises once U.S. assets exceed $60,000. I can't think of a client who's going to buy U.S. real estate in this area who is not going to have an asset that's valued in excess of $60,000. The U.S. estate tax can become payable if the decedent's taxable estate exceeds $60,000. Both of the foregoing thresholds sometimes can be changed by an estate tax treaty between the U.S. and the decedent's home country. I caution you that an income tax treaty is not the same as an estate tax treaty. Frequently, the IRS will have both with another country, but sometimes they just have the income tax treaty, so we always have to look. The thing that gets most of our foreign clients who face this issue is that not only do they have to disclose their U.S. assets, but they have to disclose their worldwide assets. And the reason for that is, in some cases, the exemption that they are allowed to have gets applied to their worldwide assets. So we've seen situations where clients have a substantial amount of their assets outside the United States in a country that with a treaty with the United States that allocates the U.S. estate tax exemption on a worldwide basis, and there's very little left to cover their U.S. real property holdings. And now all of a sudden they have a U.S. estate tax that they weren't anticipating. They have a U.S. estate tax lien encumbering that property, and it can't be sold. And even in the worst case scenario, they got penalties and interest on top of that because they failed to file the U.S. estate tax return, and now they've got to come out of pocket, sometimes substantially, to sell the property. Otherwise, it just sits there. So this issue of estate taxes is significant for non-U.S. persons. U.S. gift taxes. See how we're doing on time. I'm going to leave this to your review for the most part. Looking at the non-U.S. citizen or non-resident, the key feature there is that gifts to spouses are limited to $149,000 a year. You don't have the unlimited marital deduction that you would have if the spouse were a U.S. citizen, and sometimes this becomes a problem depending upon the situation. If the client makes gifts in excess of that amount, then they are facing that 40% gift tax liability that's discussed here. All right, let's step away from estate and gift taxes. I'm sure I've bored everybody to death with that discussion. Let's talk about something everybody's going to face, and that's U.S. capital gains tax issues. One reason to evaluate your client's status up front when you're the selling agent, listing agent, is to determine whether or not you've got a FIRPTA issue. Because as we know, FIRPTA is going to require withholding of 15% of the gross sales price. at the closing table by the purchaser, the transferee. So it arises in all of these situations and needs to be should at least be thought through up front. So FIRPTA requires withholding when a U.S. real property interest is sold. It's a broad definition of what a U.S. real property interest is. It's any interest in real estate in the U.S. or the Virgin Islands, or an ownership interest in a U.S. real property holding corporation. The term any interest includes any fee ownership or co-ownership, leaseholds, and options to acquire real estate. So it's just about everything. What is real property for this purposes of FIRPTA? Again, it's everything listed here on this slide. And this slide, timeshares sometimes catch folks. In some jurisdictions, they're treated as personal property. In other jurisdictions, they are treated as items of real estate. If they're treated as real estate, then they're going to be subject to FIRPTA. Life estates, reversionary interests, etc. These are all considered to be interests in real property. Sometimes clients are going to buy their real estate through an entity, and certainly if they get advice from us, that's what's going to happen. That means they're going to have what's referred to as a U.S. real property holding company. We want to usually use a U.S. corporation for this purpose because using a foreign corporation to actually hold title doesn't work, because foreign corporations have some really adverse income tax consequences here in the United States, so we usually avoid those. All right, so you own stock in a corporation that's a U.S. real property holding company. A corporation is a U.S. real property holding company. I should say if the value of the real property interest owned by the corporation equals or exceeds the sum of 50% of the combined value of that real property interest, any foreign real estate, certain trade or business assets. Again, this is complicated. You're going to need a tax advisor to work through that. But clearly, if the only asset is real estate and some cash, then you've got a U.S. real property holding company. Foreign corporations, as I noted, are never U.S. real property holding companies, so we don't have to worry about it. But we've got some other concerns there that I'm not getting into. Other types of entities are going to be U.S. real property holding companies. This includes ownerships by U.S. partnership if they meet certain tests, by U.S. trusts or estates that have non-U.S. beneficiaries, or ownership by a foreign trust or estate. So anytime you see these types of entities owning the real estate that you're going to list for sale, FIRPTA becomes an issue that should be discussed with the client. In order to comply with FIRPTA, the seller is either going to, in order to try and avoid FIRPTA applying to the transaction, the seller can try and comply with one of 9 exemptions from withholding, or try and obtain a withholding certificate from the IRS. The Treasury regulations governing FIRPTA describe the exemptions in more detail. Some of them are if you can prove that the seller is not a U.S. person, if you can prove that the property is not a U.S. real property interest, if you can prove that the U.S. real property sale price is not more than $300,000 and that the property is to be used as a residence by the purchaser or a member of the purchaser's family for more than 50% of the time the house is occupied by any person during the first 12 months following the date of transfer. Lengthy definition, but basically if it's going to be used as a principal residence by the purchaser or a member of the purchaser's family, not going to be rented out, you're probably going to satisfy those tests if you get to the 2-year mark. Another way to get an exemption is if you can prove that the amount realized by the seller is 0, or you go through the withholding certificate process. You can have the IRS issue a FIRPTA withholding certificate where the amount required to be withheld exceeds the seller's maximum tax liability. You can get the withholding to be a reduced amount that doesn't jeopardize the collection of tax. If the gain realized from the sale is exempt from tax, or if some other agreement has been entered into between the seller and the purchaser regarding the payment of tax and provided security for that payment. The IRS claims it's going to act on these certificates within 90 days, but who knows whether or not they do so. So FIRPTA can be managed. Again, it just requires time, an examination of the seller's situation, and a determination of whether or not they're going to qualify for an exemption or whether you want to try and seek a withholding certificate. I'm not sure how viable withholding certificates are realistically any longer because closings are happening so much more quickly than they used to in many cases. But it is something that's out there, and it might be something to consider for clients who are going to be harmed by that 15% withholding. All right, so we've talked a little bit about clients who either are U.S. persons or who become U.S. persons, and they have interests in foreign assets that they should have been reporting to the Internal Revenue Service, or they have income from assets offshore that they should have been declaring. And for those clients, particularly where the deficiencies are on the international information reporting side, remember that chart I showed you a few moments ago that had 8 or 9 different types of reports. It's when those reports are not timely filed that the clients can easily face very significant penalties and interest, can face significant penalties from the Internal Revenue Service. The way around it is to put through it without being harmed as much, is to put the client through the 2014 Offshore Voluntary Disclosure Program or one of its related programs we're going to talk about briefly. So, in 2009, the IRS began focusing resources on identifying, examining, and in certain cases prosecuting or otherwise bringing into compliance U.S. persons who have undisclosed assets overseas. As part of that enforcement effort, they have offered a series of voluntary disclosure programs by which those individuals can become compliant. The most recent program, obviously, is the 2014 program. Some of the key features of that program are listed on slide 44. I'm not going to go through them in complete detail. I would note that participating requires a full and complete disclosure of the taxpayer's non-U.S. assets, the filing of amended income tax returns, the payment of any resulting income taxes, as well as interest and penalties on those taxes, and the payment of an offshore penalty that's equal to 27.5% of the value of the foreign assets and investments that the taxpayer did not disclose. That offshore penalty covers all of the penalties which would have been applied for failing to file the information reports. That penalty is usually a bargain. I know it may sound like it isn't, but for most of our clients, that's a good deal. Their non-compliance with respect to those information reports has been so substantial and has gone on for so long that the penalties are confiscatory. I know you might think 27.5% is confiscatory, but trust me, not compared to some of the other penalties that we're talking about. In addition to the Offshore Voluntary Disclosure Program, clients who can qualify for one of these streamlined filing procedures that are included in the program might want to do so. So we've got 2 streamlined programs. We've got a streamlined foreign offshore procedures we can use for certain clients, and we've got streamlined domestic offshore procedures that we can use for certain clients. The difference between the two is determined by whether the taxpayer satisfies a non-residency test that I'm going to go over in a minute. In order to qualify for either of these 2 streamlined procedures, the client has to be able to assert under penalties of perjury that they did not act willfully in failing to file their international information reports. So they have to work with someone who's experienced drafting the non-willfulness statement so that they will be considered by the IRS to be non-willful. And I'm going to talk about that a little bit more in a minute, but that's the key distinction between the Offshore Voluntary Disclosure Program and these 2 streamlined filing procedures. So let's go to the non-residency tests. The taxpayers who live outside the United States, they want to enter the streamlined foreign procedures, the SFOP, because there's no penalty. They don't have to pay an offshore penalty. They don't have to pay any tax, interest and penalties on the tax, but they don't have to pay the penalty. In order to qualify, In addition to being non-willful, they've got to be able to prove that for at least one of the last 3 years for which U.S. income tax return filing deadlines have passed, that the person was outside the United States for at least 330 days, and they did not maintain what's referred to as an abode in the United States. So any one of those 3 years, they were outside the United States for at least 330 days, they meet that test. If they did not have an abode in the United States, then they qualify for the streamlined foreign procedures. I will say that abode has a technical meaning for tax purposes. It's not the generic meaning. It's not what you look up in a dictionary. So that if a client's going to try and come in and do this, we have to evaluate whether or not they had an abode in the United States. If they don't qualify for streamlined foreign, then they're going to be filing the streamlined domestic. If they file streamlined domestic, they've got to still do the non-willfulness certificate or statement, but they got to pay taxes, penalties, and interest on the taxes. They're also going to face a 5% penalty. All right. Non-willfulness for both programs. Again, under penalties of perjury, the taxpayer states that their failure to comply with the U.S. income tax return information report filing requirements was a result of negligence, and inadvertence, mistake, or a good faith misunderstanding of the requirements of U.S. law. That is what it says. One of the benefits of doing the full-blown OVDP and paying the 27.5% offshore penalty was that you are excused from any criminal acts that you may have undertaken with respect to those tax returns or information reports. So your willful failures to, or your willful evasion of tax, your willful failure to file information reports is going to be forgiven. It's a get out of jail free card. Because you're saying that you're non-willful under the streamlined programs, you don't get the same protection. So we're seeing people try and squeeze into the streamlined programs in order to either avoid the penalty or pay the reduced 5% offshore penalty, who are pushing the envelope too far. And the IRS has been reviewing non-willfulness statements that are starting to audit. I would expect we're going to see some prosecutions. So this is a really serious statement that the taxpayer has to work with an attorney to prepare and has to sign under penalties of perjury. It's the linchpin to getting into the streamlined programs. So clients who go into the streamlined domestic program have to file 3 years of income tax returns, pay taxes. They have to file 3 years of international information reports, 6 years of FBARs, and as I noted, they've got a 5% penalty. The SFOP is the same, except there's no penalty, as I mentioned before. Clients who are in the United States, domestic, depending on their situation, they might want to get out of the U.S. in the current year. It's a little too late now, but try and meet that 330-day requirement if they don't have an abode here and just happen to be here for a while in 1 year. Just something to think about. All right. The client has generally reported all of the income from their offshore assets. Then there are 2 additional simplified procedures that they can go through to file the international information reports that they failed to file without penalty. But they do have to include what the IRS calls now a reasonable cause statement, which explains why it was reasonable for you not to file those international information reports. That also gets signed under penalties of perjury. The IRS will take those information reports and decide whether or not your reasonable cause argument is sufficient. We haven't seen these getting rejected, so the IRS appears to be willing to accept most reasonable cause statements, again, as long as they were reasonable. Which leads to the question of whether or not it's safe to ignore U.S. income tax filing obligations. And the answer is no. There's this law called FATCA, the Foreign Account Tax Compliance Act, that's been in force since 2010, is now operational, and that's going to likely allow the IRS to catch non-compliant taxpayers. It requires banks and brokerage houses and many other types of foreign financial institutions that are located outside the United States to identify and disclose to the IRS the identity of account holders who are U.S. persons or face withholding of foreign entities' U.S. source income. That U.S. source income is really difficult for the foreign financial institution to withstand. As a result of that, what you've seen is these foreign financial institutions have gone to their governments. Most countries in the developed world and a lot of countries in the lesser developed world have entered into intergovernmental agreements, IGAs, with the United States that organizes the sharing of information from the foreign country's banks, the foreign country's financial institutions, back to the Internal Revenue Service. And if they do that, then that's going to comply with their FATCA obligations. But what that means is that there's information sharing going on. And that is resulting in U.S. persons that have foreign accounts, foreign investments, having information reported back to the IRS without their knowledge. That information is going to cover everything from the name, identifying number, assets in the account, and the income earned by the account. It's going to be pretty much the same as what would be on a Form 1099 issued by a U.S. financial institution, which leads to the question of whether a secret bank account is still secret. And the answer is it's probably not. Because of the information sharing that's ongoing under FATCA, the IRS likely already has information from foreign countries on a U.S. person's foreign accounts. The question then becomes, what are they going to do with it? Will they audit someone? Will they send letters? Is somebody going to knock on the taxpayer's door if the taxpayer's in the United States? Will they conduct a criminal investigation? Who knows? This is the cutting edge of tax enforcement. The IRS has been getting FATCA information for a couple of years. When we talk with IRS representatives at seminars, we ask about this. We told that they're actively studying it. I fully expect in the not too distant future that the IRS is going to start sending at least letters asking clients about or asking taxpayers about these accounts. We're also concerned that the IRS will either withdraw or substantially modify both the offshore voluntary disclosure programs and probably most importantly those two streamlined programs that are based on non-willfulness. We've had different IRS persons comment in public over the last few months basically saying they don't understand how anybody could argue that they were non-willful because these programs have been in existence since 2009. And so if you're not non-willful, you can't qualify for Streamlined, and therefore people who think they can qualify for Streamlined are going to get forced back into the full-blown offshore voluntary disclosure program at the 27.5 penalty rate, or what's also anticipated is that penalty rate will increase. Wouldn't be unusual to see it go to 30 or 33%, somewhere in that range. That's the conclusion. I will now take questions for a couple of minutes from anybody in the audience.
Thanks, Richard. To address a couple of the frequently asked questions, yes, this webinar is being recorded, and it will be available probably starting next week on the Maryland Realtors website, and copies of the slide presentation will be available to all of the participants. One of the questions that we have here is, can you name some countries that do have a tax treaty with the U.S.? Now, this question was asked earlier in the presentation, so my guess is they were referring to income tax treaty as opposed to estate tax.
I think the easiest thing to do would just be to Google that. Most of your developed countries have an income tax treaty. Most but not all have an estate tax treaty, but if you just go to Google and type in U.S. income tax treaties, you'll be directed to a list of all the countries that have one with the U.S. and the same for estate tax treaty. I think that's the easiest thing to do.
Very good. Now for expatriation, is this process the same for U.S. citizens who were born here in this country?
Yes.
Okay. And then the last question is a little bit tricky. The question is, what can a real estate broker ask a global client to clarify their status as a citizen, green card holder, or other? And the reason I say this is tricky is because with fair housing laws being what they are, we typically advise that realtors do not ask for citizenship details. But as we've seen from this presentation, there are a lot of considerations for foreign people who are looking to invest in real estate. So do you have any best practices as to kind of how to handle that situation?
Well, I certainly don't want to step into fair housing issues in any way. I think that you could perhaps introduce the topic by, in an indirect way without actually asking. Would probably be a way around that. So, ask, maybe talking with the client a little bit about tax issues that can attach with respect to the property. If the client is not a U.S. person, that's something that they may need to talk with a tax advisor about. You don't have to ask them whether they are or are not a U.S. person, but just say, look, if you're not a U.S. citizen, if you don't have a green card, if you haven't been in the United States for a long period of time, you may have issues with withholding on the gross rental income from the property that you're looking at. If that applies to you, then you may need to reach out to a tax advisor to get clarity. And that would lead to the discussion, because from that, everything else would flow. And the client then may just inform the realtor about their status. Particularly if you say 30% withholding, that's going to get everybody's attention. Another way may be to talk about, they're buying the property, how long are they going to hold it? When they sell it, there's this thing called FIRPTA, which has a 15% withholding on the gross sales price. If that's an issue that you want to, that you're concerned about, then either consult with tax advisor, or we can talk about it a little bit.
Very good. And some of the other questions that have come in are on this very topic. So I know that's like I said, it can be a tricky subject. And of course, for any of our members who have more in-depth questions, we have a legal hotline here at Maryland Realtors, and our attorneys, our staff attorneys, can answer questions, dealing with fair housing or any of these type of issues. So I'm looking over here. Okay. Is a realtor liable for failing to advise client on FIRPTA and some of these other matters?
Well, FIRPTA, I wouldn't think so, because that's the buyer's responsibility to collect, or the title company's responsibility to collect. I think, failing to advise a client about that going into a closing where it's going to happen jeopardizes the closing. And I would think that's not in anybody's best interest to occur. Everything else that we've talked about here are outside what I would see as the scope of the realtor's responsibility or legal responsibility. But they're just best practices. In this area, we see so many clients who are coming from outside the United States that it's not uncommon to have clients who are experiencing or will experience these issues. And I think the more a realtor can talk to the client about the issues and make appropriate referrals, if the client doesn't already have a tax advisor, I just think that's something that's helpful to the client. But I don't see any legal responsibility.
One of the respondents pointed out or made the comment that not all accountants and tax advisors are well versed in these areas. So I would think it'd be critical to, to ask those questions before, referring a client to an accountant or an attorney.
I agree. This is a complicated area, and if you're in an area in Maryland that issues like this don't arise that often, the professionals in that area may not be as familiar with it as professionals in a more metropolitan area might be. That's one. Two, not every person you go to, even in a metropolitan area, is going to be familiar with everything that we've discussed here today. So it really takes a tax practitioner, a tax attorney who is actively working in this area to render advice in many of these areas. I mean, not necessarily all of them, but certainly if we're looking at things like going into one of the offshore voluntary disclosure programs, you know, determining whether a client has satisfied the substantial presence test, expatriation, those, you know, filling out that Form 8854, that all requires someone who's done it before to do it, I would think.
Absolutely. Well, I think that that's about all the time we have today. Richard, I'd like to thank you so much for sharing this information with our membership. And I thank everyone on the phone for joining us on this webinar today. As I stated earlier, this webinar is being recorded and will be available on our website starting next week, so you can review it or share it with your Realtor colleagues. Thank you, everyone. Hey, Christy.